Hey y'all, hey. I'm so tired. I did not want to do this, but I had so many inbox messages and so many questions that were not necessarily answered in the live video I did last night. I'm so tired and I got so much going on, but I want to follow up and answer a few questions. I probably won't answer them all, but y'all are still welcome to inbox me. If it gets too deep into your particular issue, then you're going to have to schedule an appointment for a consultation. The information that I'm trying to give you guys is general information. I can't, tell you exactly what needs to be done on your case because most of the time you're going to need a lawyer to file something for you, whether it's an estate or whether it's to prepare a deed for you, whatever is needed. For the most part, you're going to need a lawyer to do some of those things. What I'm trying to get you to understand is the attorney's fees that you spend prior to your death will be a lot less than the attorney's fees that you will spend on the back end if you wait and have your children have to deal with this after you're already deceased. Okay, so I wrote down some stuff so I wouldn't leave anything out. So when I talked yesterday about the notice to creditors, so when you file an estate with the court, you file a petition to open an estate. If there are heirs, more than one heir, then the other heirs can file what's called a joinder to join into the petition to open the estate. Then once everybody has joined in the petition to open the estate, then the court will order that the estate is hereby opened, and that's when you have to put a notice to creditors in the newspaper. When you put that notice to creditors in the newspaper, it runs 3 weeks sequentially, 3 weeks in a row sequentially, and that means that after the last notice runs, that the creditors have 90 days from that last date to enter an appearance on the estate and file a creditor's claim on the estate. That's one of the reasons why I say that if you don't deal with things before you die, then you open the estate up for creditors to come in, and your estate will be more vulnerable to creditor access. But if you deal with things before you die, then it'll be less likely that creditors will be able to come in and take assets from your heirs. Now, I talked yesterday about my son being my only heir at law. So I'm going to tell you what an heir at law is. An heir at law means that when you die, you have certain people who are legally authorized to receive your assets under the laws of the state of Mississippi. So that means that if I was married, then my heirs at law would be my husband and my son. If I had more than one child, then my heirs at law, but I wasn't married, my heirs at law would be my children. If I didn't have any children and I didn't have any husband, then my heirs at law would be my parents and my siblings. So it just depends on who you have left in your life, who will be your heirs at law. Now that brings into the picture the sibling rivalry thing, because we have so many times when siblings may have a different mama, but they got the same daddy. Or they got the same mama and they got different daddies, whatever. But, sometimes or they have the same daddy and have different mamas. But either way, the sibling rivalry comes in when it's like, that's not my daddy's child. I want you to prove that you're my daddy's child. My daddy you never had my daddy's last name, and my daddy's name is not on your birth certificate. How you going to prove you my daddy's child? And so that sibling rivalry comes in. So I had a case a long time ago where the young lady said that her brother was not her brother, that you're not my daddy's child. And so we had to exhume the body of the daddy to do a DNA test to find out whether or not the brother was actually her brother. And then by the time we got through paying for the body to be exhumed, he paid his attorney's fees, she paid her attorney's fees. She ended up getting less money than she would have gotten if she would just split the money with her brother. So, it's just like sometimes it's worth it and sometimes it's not. Another thing you have to think about is your heirs at law if you are married to somebody but you with somebody else. Now, a lot of times people will die and they will be legally married to their wife, but they've moved on. They've been living separate lives for the last 15 years. But if he messes around and dies, or if he messes around and has a wrongful death lawsuit like Eric Garner up in New York, he was still married to his wife, but he was living with his girlfriend. They had a baby together. But that baby mama ain't getting nothing. The baby gonna get some money, but it's gonna go into a trust fund for the baby. But she ain't gonna get nothing. His wife and his kids gonna get the money. His kid with her and his kids with his wife. But his wife is gonna take a percentage of the estate, but the baby mama ain't gonna get nothing because she's not related to Eric Garner. She was not related to him at all. So unless he had a will, or if he had a life insurance policy where she was the beneficiary, she got nothing. Absolutely nothing. So if your boyfriend or your girlfriend is still legally married to someone else and they die, and then that person's spouse or their children come put you at your house, don't be looking crazy, because you need to make sure that your man or your woman is handling their business and make sure that they are legally divorced before you build a life with them. Because what will happen is you move into the house with him or you move into the house with her, and then he or she dies. Then that house, if it's in his name alone and your name ain't on it anywhere, and you're not, he didn't deed it to you, and y'all don't own it as joint tenants with rights to survivorship, and he didn't leave that house to you with a deed, then his children and his wife gonna come put you out. You ain't gonna know where to stay. Or his children and her husband gonna come put you out and you ain't gonna know where to stay. So you gotta make sure that legally your mate is prepared to be with you unto death. It just is what it is. I had a situation where I was in court one day, and I was a baby lawyer. I was probably about 28. And this couple came in and they were trying to get a divorce. And I knew them. They had been separated since I was like 5 years old and I was 28. And so I asked, they had done something wrong with their divorce papers, and I asked the judge, could I approach the bench? And he said, yes. And I said, Judge Thomas, I'll do it. I'll fix it. Whatever's wrong with it, I'll fix it. And he was like, well, y'all can go with Miss Payton, and whatever she charges you to fix this paperwork, you just got to pay what she charges. I said, Your Honor, I'm not going to charge them a thing. I said, I've known them since I was a little girl. I said, they've been separated since I was 5. If nobody in this courtroom needs a divorce, they need one. I said, so I'll take care of it. So, but if he would have died, or she would have died while they were still married, she would have been his heir at law. And so when you deal with wrongful death claims like with Eric Garner, the court is going to determine who your heirs at law are. And so if your heirs at law are an estranged spouse, then that estranged spouse is going to get your money when you die. It just is what it is. Another thing you have to remember is that you cannot bequeath your children to people. That's something that's very important to know. You cannot bequeath your children to anyone. So you cannot love your baby daddy. Your baby daddy can be a deadbeat. He can be whatever. Your baby mama could be, have estranged from her children. But if you die, if one parent dies, then the assumptive parent is going to be that other parent. So that means that you can't say right in your will, I want my mama to take my kids when I die. You can't bequeath children. The law is going to be followed, and the person who is the heir at law to that child is going to take that child into custody. So people get mad with chancery judges all the time because they follow the law, and that child is going to go with that other parent. And especially when there's a wrongful death lawsuit, and and there's money, and then the daddy comes swooping in out of nowhere wanting to take the child. That's when the trouble starts. So make sure that you understand that you can't do that. So make peace with your baby daddy, make peace with your baby mama, so that if something happens to you, your children will be comfortable in the space with that other parent. Because if you don't make peace with that, then your children are going to end up in a household that they've never been in. And that's not going to be a good look. So make sure that you make peace with those situations, because if that other parent wants that child, if that parent is not otherwise unfit, you got to be real unfit. So if that parent is not otherwise unfit, the court is going to give that child to that other parent. So make sure you make peace with that, and make peace with your children's parent, your children's other parent, because that's where they're going to go. Because you cannot bequeath a child. You cannot say in a will that I want my child to go with this person, because that's not the law, and it's not gonna work. let me see what else I need to talk about. Make sure I want to cover. There are different types of land ownership. We talked about that yesterday, but I kind of like glossed over it. You can own land in different ways. You can own land as joint tenants with rights to survivorship. That means me and you own the property. If one of us die, then the other person gets the property. That's usually how spouses do it. And like I said, a lot of times people get married later in life, and then they end up disinheriting their children, because if they give their spouse joint tenancy with right of survivorship, then when they die, that spouse is going to get the entirety of the house, and the children won't get anything with regard to that piece of property. So if you don't want to disinherit your children, then you allow you and your spouse, if you get married later in life, to own the property as tenants in common. And if you own it as tenants in common, then when you die, your half will go to your kids and his half will go to his kids. And that's how you stop that from happening. You could also do a life estate. Like I told you yesterday, I have a life estate in my property with remainder to my child, so that my child won't have to go and open an estate so that he can have my house. But if there's still a mortgage owed on my house, my son is going to have to pay the mortgage. Otherwise, he's going to have to sell it and get the equity out of it and go on about his business. But if he wants to keep the house, he's going to have to pay the mortgage until the mortgage is paid off. That is a way that your children are still liable for your debts after you die if there's a lien on your property, unless you have credit life on your mortgage or you have credit life on your car. Then they can keep a piece of property with a lien on it. They can keep a piece of property with a lien on it. If you put credit life on it, it will pay it off at the time of your death. Otherwise, they're going to have to pay the note if they want to keep that asset. Okay? This is going to be short, y'all, because I swear I'm so tired. I'm so tired. I talked about holistic wills, and holistic wills are... holistic wills are better for personal property. They're better for like who you gonna get your pearls and who gonna get your TV. If you have a paid for car, you got an old paid for antique car, and you want to say who's gonna get it. Holistic wills are good for that. So, but you gotta have a notarized document in order to pass real property, which is a house. Land. And you remember yesterday I was saying that, I've had siblings to come in and they mad because, my brother coming on my piece of the property, my sister coming on my piece of property. But what you got to understand is if that property is still in your parents' name, then the entirety of the property belongs to all of y'all. And when you pass a piece of property, the deed is going to say, I hereby convey to you this piece of property with all improvements and appurtenances thereunto belonging. And what that means is any house that's sitting on that property belongs to the land. So if you own the land, you own the house. So if your house is sitting on air property, then it belongs to everybody. So you need to go and get that land. Partitioned over in Chancery Court. You're going to have to open an estate. But the best thing to do, like I told you yesterday, is to go ahead and talk to your parents, get it surveyed and partitioned before they die, and then your parents can give themselves a life estate in that property with remainder to that particular partitioned section of land to the siblings that they want to have each section of land. It's better to handle things while you're still alive, because that way your wishes will be met. Because after you die, unless your wishes are written down, they will not be taken into consideration. The law will take over. The heirs at law will take your property, and you won't have anything to say about it because you can't say nothing no more because you dead. So do it now. Do it now. Do it tomorrow. Do it next week. Do it soon, because just as sure as you were born, you will die. You may not want to talk about death. You may not want to deal with death, but that's not going to stop death from happening. So you need to go ahead and deal with it now so that your children won't have a mess to clean up after you're gone, and they're spending more money than the money that's in the estate trying to clean up, trying to get stuff. Because if you have a bank account that doesn't have a whole lot of money in it, you can get it's called a small claims affidavit you can do, and you can get money that's in a bank account. You can do a small claims affidavit that says to the bank, look, we need this money to bury this person. This is all the money they have. These are their heirs at law. I'm entitled to receive this money on behalf of my husband. I'm entitled to receive this money on behalf of my sister, my child, blah, blah, blah. You can do a small claims affidavit after somebody is dead to get a little money out of it. But it depends on how much money it is, because it has to be a small claims affidavit. It can't be over a certain amount of money. So the best thing to do is make all of your bank accounts POD to someone else who is going to take care of your funeral arrangements. Even if you want to make a POD to the funeral home, you can do that. If you want to do that, make a POD to the funeral home so the funeral home can take the rest of the money that's needed to pay for your burial or your, in my case, cremation. I want to be set on fire like King Arthur. Like, push back. I want y'all to all go to jail for improper disposal of a corpse when y'all push me out in the middle of the lake out there at Paul B. Johnson and then shoot an arrow and set me on fire like King Arthur. I'm just saying. Anyway, now what y'all got to understand about powers of attorney. We talked about this yesterday. Power of attorney dies with you. So you can have power of attorney over somebody, but once they die, your power stops. Because you have power of attorney over that person's estate, their living estate. You don't have power of attorney over a dead person. You can't. And if a person is unable to give you power of attorney, you have to go to court and get what's called a conservatorship. That's where the doctor has to say that this person is unable to take care of their own affairs and they need a conservator over their estate. It's it's kind of a guardianship like you would have over a child who is incapable of taking care of themselves, but it's called a conservatorship when it's for a grown person or for an adult who needs protection of their assets and protection of their person to make sure that they're taken care of. Oh yeah, and speaking of that, you want to do an advance directive. My son knows that I don't want to live. He's the sole decision maker anyway. But, if you have more than one child, you need to have an advance directive, because advance directives are what tell people what to do at the hospital. Because at the hospital, your children in there fight. No, mama, I want to leave mama on the machine. And they'll leave mama in a vegetative state on the machine for 2 years. But mama might not want it there. I know I don't want to do that. I don't want to be left in a vegetative state. I don't want to be left in a state where somebody's going to have to turn me and feed me and change my diapers for the rest of my life. My son knows that. So it's like, but if you have more than one child, your children may not be wanting to pull the plug. That's what they call it, pull the plug, or take you off the ventilator, whatever. You may have one child that doesn't want to do that. So if you have an advance directive, then your wishes will be taken, only your wishes, because you have an advance directive. So your children don't get to tell the doctors what to do. You have already told the doctors what to do. If you get to a point where you're in a vegetative state, and you get to tell them whether you want them to take heroic measures to try to save you, if you want to let them, tell them to just let you go on to glory. I want them to let me just go and go to glory. Let me go and go. I shall see him for myself. And then if I see one of my exes up there, I'll be like, oh, Lord, y'all just let anybody in here, don't you? But anyway, and the Lord gonna be like, "Gay, don't start." Anyway, so do your advance directive, and let people know how you want things to happen. If you end up in a car accident, you never know. You may end up in a car accident and be brain dead. You may have all these different kinds of things going on that will put you. You can have a stroke. You can have a heart attack that will put you in a coma, and then you won't be able to tell nobody what you want to do. So do an advance directive with your doctor's office and tell them, this is how I want it to do. This is how I want it to go. If something happens to me, I want to make sure that, they take heroic measures to try to save me, or I want to make sure that they don't take heroic measures to save me and let me just go and go to glory. What else? I already talked about that. Bequeathing children, you cannot do that. Most banks do not charge. Somebody asked me yesterday if you have to pay a fee for a payable upon death at the bank, POD, pay on death to this other person. Like I said, my bank accounts are POD to my son. My law office accounts are POD to another lawyer because my son's not a lawyer. So the lawyer would handle all my business with regard to my law practice, and then he would give the rest of the money to my son. But the rest of my accounts are POD to my son. So when I die, he don't have to be running around trying to get no small claims affidavit to try to get my money out of my account. It'll already be his money because it's POD to him. So he can just walk up to the bank and say, I need to, draw this money out and put it in my account. I need to transfer this money to my account, blah, blah, blah. It's because it's his money at that point. Well, as soon as I die, as soon as I draw my last breath, that's his money. As soon as I draw my last breath, this house is his. It's just things that he just does not have to do. He doesn't even have to plan my funeral because I've already done that. I've planned it. all the way down to who gonna tote my ashes and who gonna be the MC, what songs will be played, who gets to talk at my funeral. All of that stuff is done. Ain't nobody gonna be up there standing over my body lying about what good friends we are, and you ain't gonna be looking down at my dead face talking about I look like I'm asleep. I ain't asleep, I'm dead. And if you weren't looking at my face while I was yet alive, you ain't gonna be looking down at my dead face. We not doing that, because I'm gonna be some ashes in an urn. And my son gonna take me to Hawaii. Take me to Hawaii and, just he could throw me in the volcano. I don't care. I'm gonna be dead. I don't care about what you do with my body, but I don't want my body buried. That's one thing. And then I got a list of people who can see me dead. You know how I'm saying my son is my only heir at law, and he gonna get everything when I die. If the people who ain't on that list see me dead, he ain't getting nothing. And he needs to know that he will be watched. I got spies. I got spies that's gonna watch and make sure people don't be coming in there trying to take pictures of me like they did Whitney Houston. My family got 24 hours to come see me, and then they throwing me in the incinerator. Okay. Let's see what else. So somebody asked me whether or not spouses and children can be on deeds together. And yes, they can. You can put whoever you want to put on the deed. You can whoever you want to leave your property to, you can put them on the deed. If you want to leave your land to the person that bring your groceries to the car at Walmart, you can put that person's name on your deed. You can put anybody's name on your deed after the words convey that you want. That's your business. That's your land. As Tabitha Brown said, that's my business. So you can put that. You can put it that way. You can do it that way. Whoever you want to convey your property to, whoever you want to get your property when you die, that's who you can put on your deed, which is absolutely anybody. Which is, like I said, people who are still married to another person, they should, put their new person, like they got a girlfriend or, a baby mama, like Eric Garner, like I said before about Eric Garner, he would have wanted to put her name as beneficiary on a life insurance policy. Or he would want to prepare a will and say that when he died, he want everything in his estate to go to her and his children. And then he could leave his wife $1, the one that he was still married to. He could leave her $1. That's how you disinherit someone. You do not leave somebody out of the will, because the court may presume that you've made a mistake. So if you want to disinherit someone, like for instance, if I want to give all my money to Southern Pines Animal Shelter instead of giving it to Kobe, I would say I hereby leave all my assets, real, personal, alike, to Southern Pines Animal Shelter. And I hereby bequeath to my only son, Gabriel Payton, $1. That's how I would disinherit him, because that would let the court know, yes, I know I got a child, but he ain't getting none of my stuff. You know what I'm saying? That's what you have to do. If you want to disinherit someone, that's how you do it. You leave them $1. So that's your way of letting the court know, I know this person exists. I know this person is my heir at law, but I don't want them to have none of my stuff. So don't leave them out. Leave them $1. I ain't telling you what I heard. I'm telling you what I know. Okay, so, let's see. I think I talked about everything. I guess I'm gonna go back and read and see if y'all have any questions. Like I told y'all before last night about my parents. When my parents died 17 months apart, and then the house burned down a year after my mom died, and so I went in to try to probate my mother's estate, because I had to have the children named as the heirs at law. But I thought that the house would be in my mom and dad's name. I thought that my mama would have had rights of survivorship, and they would have owned the house, joint tenants' rights of survivorship, but they didn't. My daddy's name was the only name on the house. So what I had to do is I had to go back and probate my daddy's estate first, because he died first, have my mother and the children named as my daddy's heirs at law, and then I probated my mother's estate, so that we could be named as her heirs at law, so that one of us could act as administrator and deal with the insurance company, so that we can separate and divide the proceeds from the total loss of the house. So, I mean, and it's just like, people can save themselves a lot of drama by dealing with these things before they die. Because if you leave if you say, I'm giving myself a life estate in this house, and then I'm going to leave as tenants in common to this child, this child, this child, and this child, my 4 children, okay? So if you do that as tenants in common and not with rights of survivorship, so what that would mean is that when one of the children dies, then their portion will go to their children. And then, but if you leave it to them with rights of survivorship, then when one of them dies, then the remainder will go to the other three. And that would disinherit your grandchildren. So, it gets kind of complex. So I don't want to get too deep up into it. Your lawyer can explain this to you, but I'm telling you, go see a lawyer soon. Don't wait until your mama has dementia or or somebody's in a coma before you try to figure out estate assets, because it's too late at that point. It's too late at that point. You cannot do a will because the way a will starts is I, so and so and so and so, of sound and disposing mind, which means I know what I'm doing. If I got dementia, I can't bequeath nothing to nobody. So that means you got to do it while your parents are in their right mind. Do it while you're in your right mind. Do it while you can still make decisions for yourself. Because once you're in a coma, once you're dead, you can't make decisions for yourself anymore. Other people are going to be deciding what happens to your stuff. And you want to be in control beyond the grave. So go on and control it now by dealing with it now. Okay, let me see. Oh, Lord, there's a lot of people in here. Thank y'all for watching. Y'all, please share this video with your friends and family because people need to know this kind of stuff. And I'm just doing this one as a follow-up to kind of fill in some gaps that I left out last night so that, people will understand some of the terminology that I used last night, because I don't like talking over people's heads. And I like people to understand the words that are coming out of my mouth. I want people to understand what's going on. A lot of lawyers like to use big words to make you feel dumb so that you will pay them $1 million to do stuff that ain't really worth that much. So I like talking to people so that people to understand the words that are coming out of my mouth. So I use plain English, but some of these terms that you use in a state law, there's no other word to be used for it. So I tried today to give you some definitions of some of those words so that you'll understand the words that are coming out of my mouth. And I won't be sounding like Jackie Chan to you. Okay, I'm sorry. Y'all know y'all saw Rush Hour. Come on. All right. Thanks so much for all of this. Audrey, you're welcome. How do I get access to yesterday's broadcast? Just go to my page and scroll up. It's in my timeline. So if you want to see the one from yesterday, just go and scroll up on my timeline and you can see that one. Alice says, do you have to pay someone's student loans after their death? That's a really good question, but that was one of the reasons why I was telling y'all to go ahead and disseminate your assets prior to your death. Because if your children have to open up an estate to get your money and to get your house, you're also opening up your estate to your creditors. Now, there are certain creditors that you can't run from. Like if there's a mortgage on the house, if there's a piece of property that is the piece of property is being used as collateral. So if you have a car that has a lien on it and you don't have credit life on that car that pays that car off when you die, then your children or whoever's going to get that car has to continue to pay the car note. Same with the house. If the house is not paid for and you don't have credit life on the house, then whoever wants to keep the house is going to have to pay the note in order to keep the house. Now, that's why you would go ahead and deed the house. Give yourself a life estate in the house with remainder to your children. That way your children won't have to go and open up an estate to pass your house along. And because if they open that estate, once that judge signs that order opening that estate, then the next thing your lawyer is going to have to do is do a notice to creditors in the newspaper that's going to run for 3 weeks. And from 90 days of that last time it ran, that's how long that creditor has to come in and say, I got $100,000 lien on this property and I want my money. I'm trying to save y'all money on the back end by telling y'all what to do on the front end while you yet alive. So if you don't want your student loans, the student loan people coming trying to get money from your heirs, then you better make sure you bequeath your property before you die with a deed and with a POD on your bank accounts. It's so easy to do because, like I said, most people, like I don't have a bunch of money market accounts. I don't own 13 houses. I do have some intellectual property because I've written a book and I've got some music, but most people don't have intellectual property. They don't have that kind of stuff. So you might as well just go ahead and deed your house to your children now and put POD on your bank account so your children can get access to your money so they can bury you, and so that your creditors won't be coming in there trying to take all your money and your children end up disinherited and get nothing. Okay. Let's see. Hey, Tiana. Who said don't start? That's what the Lord told me, Adrian Boone. He's like, don't start, because I came in there and saw my ex-husband, and I was like, y'all just let anybody in here. Anybody can come in here. That's what y'all doing now, Jesus. And then he told me don't start. So I said, okay, I'm sorry, Lord. I'm going to be good. I'm finna go over here on my cloud and mind my own business. That's what I'm going to do. That's what I'm going to do. Because that's how I bound it on earth, so I'm going to bound it the same way in heaven. Yeah, I'm sleepy and delirious. Okay, let's see. Let's see the list. Let's see. I don't remember what I said, so I don't know what you're talking about. Ain't no telling what I said. I don't know. Yeah, Audrey, does Mississippi law require wills to be probated? It depends on what's in the estate. Like, and who are the heirs and how many heirs there are. If there's just one heir, like, Audrey, that I just have one child. So, I can have a will till I'm blue in the face unless I will it to somebody other than my child, then he's going to get everything. So, there's no requirement that a will is probated. The time that comes when the will has to be probated is when there's a dispute about who's going to get what. That's when people start, dad is dying, who's got the will. Everybody wants to know where the will is so they can know what daddy wanted, because daddy's probably at this point got dementia or he's in a vegetative state and nobody knows what daddy wants. So it's like daddy's dying, who got the will, so that they can probate it. So it depends. You don't have to probate a will in every estate, because if you did, then everybody would have to do one. But everybody don't go to Chancery Court and do an estate when they die. But it's you can do if you do probate, you can either probate a will, but if you can't find the will, or if there is no will, you'll probate an intestate estate, which means that the person died without a will. Intestate means you died without a will. So if you have any follow-up questions on that, just let me know. Y'all make sure y'all share this with your friends, and so that they can learn some of this stuff. If you bound it on earth, he'll bound it in heaven. If you loose it on earth, he gonna loose it in heaven, Adrian. Girl, if I could sing y'all a song, I would. I ain't got no voice. I went to go see the ENT doctor today, trying to figure out what's going on with my voice. He said I got acid reflux. So, I guess I don't. Anyway, my doctorate is in law, so I can't question what that man said. I don't know whether he right or wrong. But look at my face. That's a mess. I can't sing. I ain't got no voice. I ain't got no voice. I don't think I probably could sing His Precious Lord, because I don't need no voice to sing that. I am so doggone hoarse. I know you can hear how hoarse I am. I know you can. Go to YouTube and put in Gay Polk-Payton. You can hear me sing whatever you want to. Whether it's the national anthem, God Bless America, At Last, I Will Always Love You by Whitney Houston. I got some Adele on there. Take It All, Don't You Remember. I got all kind of stuff on there. And one of these days, I will sing for y'all. I will sing for y'all when I do a live video, but not today. I'm sorry. My mama told me that when somebody told me to ask me to sing, that I should sing. So, honoring my mama's memory, I guess I will sing the only song that I know that I can sing right now, which is Precious Lord, take my hand, lead me on, let me straight. I am tired. I am weak. I am worn. I have honored my mama's wishes. Okay? Because I sung. I did. I sung like shoot. I did the best I could. Okay, I love y'all, and y'all have a wonderful, wonderful, wonderful evening. And I pray that this message has blessed your life, that this message has helped your family to heal before the healing. Because you have enough to deal with when you've lost your loved one. When mama died, it's just like your whole world is crumbling. My mama was my rock. So the fact that I am being able to hold a coherent conversation without her being on this earth is a miracle even to me, because she was my rock. My mother was the kind of woman who drove 4 hours to Oxford to hear me to sing the national anthem, which takes me a minute and 35 seconds to sing. So it's just like she was my rock. This is the woman that when I was talking about quitting law school, I came home that weekend and she got in my car and went back to Oxford with me and told me she was going to stay with me at Ole Miss until I got my legs back under me, because I was not going to quit law school. So it's just like she was my rock. But so when you lose your mama or you lose your daddy, the last thing you need to be thinking about is who's going to get what and how we going to bury mama, how we going to do this, how we going to do that. That's the last thing you need to be worried about when you already lost your best friend. So parents, don't do that to your kids. Don't do that to your kids. That's why I've already done everything for my son. My son ain't gonna have to do nothing but pick up that iron, get on the plane and go to Hawaii and spread my ashes. And I'm gonna leave him enough money that he can do that. So make sure that you do that for your children. Do that for your children. I know sometimes they just act like they crazy and they ain't got no sense, and and they spoiled and entitled, but those are your babies. So protect them even unto death. Handle your business. Get you some deeds done. Run over to the bank tomorrow and put POD on your accounts so that it'll be payable on death to someone who can pay for your funeral expenses and can disseminate your assets to your other heirs. Okay? All right, y'all. I'm trying to y'all make sure y'all share this, and I will talk to you guys another time. But I said I was gonna try to come on today, and so I was getting ready to put my pajamas on, and I said, let me go over here and answer these questions and fill in these blanks that I left yesterday. I went through the list and I covered everything. So y'all have a wonderful night. You don't have to take my advice, but I've been practicing law for 25 years. I made a B+ in property law and in wills and estates. So I know what I'm talking about. Okay? So handle your business. Handle your business. Handle your business. Do not leave a mess for somebody else to clean up. All right? Y'all have a great night.